Hi, everybody. It's Joy and Scott Anderson from the Anderson Injury Law Firm, and we are back talking about the most frequently asked questions that Scott gets when people come into his office. So, hi, Scott. How are you?
I am doing all right. Thank you for having me.
So, the first 2 weeks, we talked about how long is this going to take, which everybody wants to know, and how much it's going to cost. This week, we're going to talk about do I have to sue the other driver, which I thought was really nice because people don't want to be in a lawsuit. They don't want to sue somebody else that's kind of an unknown and scary, if you're being honest. So that's the question of today. Do you actually have to sue the other driver?
The short answer is you have to be willing to sue the other driver. The vast majority of cases are able to resolve without a lawsuit ever being filed. Every law office is going to be different on their how frequently they file lawsuits and what their ratios are. In our office, we file lawsuits about 30% of the time. So in 70% of the cases, the answer is no. Someone does not have to sue the other driver. Like I said, they have to be willing to sue the other driver because the relationship, a victim of someone else's bad actions in a car accident, that victim doesn't have a direct relationship with the other driver's insurance. Since they don't have a direct relationship, the person can't go sue that insurance company because there's no relationship there, no privity. So what ends up happening is they have to be willing to sue, and like I said, in 30% of the cases, we end up having to sue the at-fault driver. The goal is to get the insurance company to do its side of the contract, which is to hold harmless and indemnify their insured, the other driver. And what that basically means is they have a duty to defend, meaning they hire an attorney for the other driver, and they basically field the defense for the driver. They also have a duty to indemnify, which basically means if the victim of the car accident gets a verdict, the insurance company is obligated to pay that verdict up to its policy limit. There, when I say up to that policy limit, there are all kinds of asterisks that go next to that because there are a lot of things that it's not technically correct to call it third party bad faith. That doesn't technically exist, but there's something that is geared towards third party bad faith to get what's called an excess verdict, to try to get a insurance company to pay more than their policy limit. That is a long, convoluted conversation. So that's why I'm putting big asterisks there. But the short version is they have to be willing to sue the other driver because otherwise they have no way of getting to the insurance company that insures the at-fault driver.
And I think that's the hard part because when you're talking about an accident, it's an accident. It wasn't intentional. And I know when I got in a car accident, I was at a stoplight and a young girl hit me, um, rear-ended me, and she was just a kid, and I was like, I don't want to sue, I don't want to sue her. She'd had her license for, I don't know, 6 months maybe, and you knew it wasn't intentional. And I think that's kind of like the hard part is, there was no intention behind it, but that's why we have car insurance.
Yeah, and I think that's a common misperception. Filing a lawsuit does not say that you are saying the other person was malicious or did something intentionally to harm you. Filing a lawsuit is our legal system's way of resolving disputes without violence. So instead of saying, hey, you hit me, I'm now going to come after you and your family and physically attack you. Our legal system says, let's resolve these amicably and in a way that doesn't cause physical violence. And that's with a lawsuit. So all a lawsuit is our civil way of resolving disputes without using what has historically happened throughout human history of, an eye for an eye, or there were some things back in the day called combat courts, where to resolve a dispute, you would get a champion who would go out, and if your champion killed the other champion, you were right. There, the Salem witch trials, that was a form of dispute resolution. So our legal system has come a long way to say we're not going to use violence to resolve issues. We're going to use a civil way of letting people dispute things in a courtroom where there isn't violence. There's just arguments that get made, and so it's not a malicious thing of filing a lawsuit. It's simply saying I want to utilize my legal rights to protect myself from wrongdoing.
Yeah, and that's a perfect way to say it because it's not personal. With some accidents, there's long-term injuries that you have to protect yourself
Yep.
from.
Yeah, we can, I guess, save that for another day because it's another long conversation. But it is amazing the medical research on injuries. Just a quick synopsis. A lot of people look at minor accidents and they say, "Oh, how could anyone be hurt?" It was a 5-10 mile per hour accident, and the medical studies show that people get hurt and sometimes get hurt in permanent ways with long lasting effects from very minor speed accidents.
Awesome. Love it. Well, I hope that answers some questions about if you have to sue the other driver and kind of the steps and what that means. And our next one, we're going to talk about what about my car? So we thank you for watching and joining us, and we will see you next time.
Well, thank you for the time.
Take care.